Right now, the glowing screen in your living room or the silent cylinder on your kitchen counter is legally authorized to harvest the intimate details of your daily life. This is not a technical malfunction, but a deliberate, legally binding feature embedded directly within end-user license agreements, or EULAs, that you click to accept without reading. These digital contracts form the invisible foundation of a massive, unregulated surveillance network operating directly inside your home, transforming private sanctuaries into active nodes for corporate data extraction. By powering on a newly purchased smart device, consumers unwittingly enter into binding arbitration and data sharing agreements that entirely bypass traditional privacy expectations. EULAs are not mere technical guidelines or user manuals. They are ironclad legal shields designed by corporate attorneys to grant manufacturers broad, irrevocable permissions for constant data collection. This legal vulnerability allows companies to monitor your physical presence, your daily routines, and your private conversations without ever needing to request a formal warrant or explicit daily permission. Consider the specific, highly intrusive mechanisms of smart TV surveillance. Modern connected televisions utilize automatic content recognition, a sophisticated tracking technology that continuously captures audio and video fingerprints of absolutely everything displayed on the screen. This system matches those fingerprints against massive centralized databases in real time. This persistent monitoring records your viewing habits, your gaming schedules, and even the presence of encrypted streaming traffic, systematically stripping away the anonymity of the entire household for the sake of targeted profiling. That raw behavioral information does not remain isolated on the local hardware. It is instantly transmitted to remote servers where it is categorized, packaged, and sold to third parties. The initial user agreement creates a permanent legal gateway for this extraction, allowing device manufacturers to monetize intimate behavioral patterns under the deceptive guise of improving user experience. This leaves the consumer entirely exposed to secondary data markets, where their digital identity is traded without their ongoing informed consent. This relentless extraction directly threatens fundamental digital autonomy, particularly when evaluating voice assistant data. When a smart speaker is plugged in, its microphones are ostensibly designed to listen only for specific wake words. However, the legal parameters hidden within the EULA often permit the retention of audio snippets captured immediately before and after that trigger. These fragments of private conversations are stored indefinitely on external servers, creating a permanent, highly searchable auditory record of the intimate home environment. To understand the sheer gravity of this legal exposure, one must examine the intersection of these contracts with the third-party doctrine. Under current interpretations of this legal principle, which dates back to the 1970s, individuals lose certain Fourth Amendment protections against warrantless search and seizure the moment they voluntarily hand over information to a third party. In the analog age, this applied to bank records and telephone dialing logs, but today, it applies to the heartbeat of your smart home. In the context of our modern digital infrastructure, clicking agree on a lengthy EULA constitutes that voluntary handover. By accepting the terms of service for a smart thermostat, a connected doorbell, or a robotic vacuum, users legally consent to share their behavioral data with the manufacturer. That corporation can then legally transfer your aggregated data to countless data brokers, advertising networks, or even law enforcement agencies, entirely bypassing the need for judicial oversight or a probable cause warrant. The Supreme Court case of Carpenter v. United States recognized that certain digital data, specifically historical cell site location records, requires a warrant due to its deeply revealing nature and the impossibility of avoiding mobile phones in modern society. However, the constitutional protections established by that landmark ruling are actively and aggressively circumvented by the explicit consent clauses buried deep within smart device EULAs. The contract serves as a legal loophole, overriding your expectation of privacy. Those specific clauses act as a contractual override to constitutional safeguards. The EULA dictates that the user has already explicitly permitted the collection and dissemination of their data, rendering the need for a warrant obsolete in countless civil and commercial contexts. The device manufacturer holds the absolute keys to the digital profile, and the user, simply by wanting to turn on their television or adjust their thermostat, has legally surrendered their fundamental right to object. The shadow profile generated from this constant, legally sanctioned data collection is staggering in its scope. It aggregates granular sleep patterns from wearable tech, real-time occupancy data from smart lights, and consumption habits from connected refrigerators. This is no longer merely about serving targeted advertisements on a web browser. It is about the creation of a comprehensive, highly predictive behavioral dossier that can silently dictate insurance rates, determine creditworthiness, and even influence future employment opportunities. The legal threat deepens exponentially when considering the most vulnerable members of the household. Children interacting with voice assistants or smart toys are subjected to the exact same pervasive tracking, despite the existence of federal regulations. The Children's Online Privacy Protection Act, commonly known as COPPA, was specifically designed to mandate verifiable parental consent before any corporation could legally collect personal data from users under the age of 13. Yet corporate entities consistently exploit massive loopholes within these federal protections by classifying smart home devices as general audience products rather than child-directed toys. Manufacturers successfully bypass the strict prohibitive requirements of COPPA. They rely heavily on a concept called household blending, where data from adults and children is mixed into a single, indistinguishable profile, making it nearly impossible for regulators to enforce age-specific privacy limits or penalize the aggressive data harvesting of minors. A critical, actionable line of defense has emerged at the state level to combat this systemic corporate overreach. The California Privacy Rights Act, or CPRA, provides a robust, legally enforceable framework for reclaiming digital consent. This landmark legislation grants consumers the explicit legal right to know exactly what personal data is being collected, the right to demand its immediate deletion, and, crucially, the right to legally stop it from being sold or shared with third-party brokers. Utilizing these CPRA rights is a mandatory first step for anyone serious about defending their digital autonomy. Even if you reside outside the borders of California, many major technology companies have adopted these compliance standards nationwide to avoid the logistical nightmare of maintaining fractured, state-by-state data systems. You possess the power to legally demand that a manufacturer restrict the use of your sensitive personal information, effectively forcing them to close the data pipeline they opened through the EULA. However, exercising these vital rights is rarely a straightforward process. Companies deliberately deploy sophisticated dark patterns within their user interfaces, intentionally obscuring privacy settings behind labyrinthine menus, misleading toggles, and highly confusing legal language. The ultimate goal of this design strategy is to induce consent fatigue, ensuring that the average consumer simply gives up in frustration and accepts the default, always-on tracking configuration that maximizes corporate profit. To pierce this layer of corporate obfuscation, a rigorous, systematic audit of every single connected device in your home is absolutely required. Begin your defense by navigating directly to the network settings of your smart television. Locate the terms and conditions or the advanced privacy menu and explicitly disable automatic content recognition. You must hunt for this setting as it is frequently disguised under benign labels such as viewing data, interactive TV services, or enhanced viewing experiences. Next, you must directly address the persistent voice assistant data logging. Access the companion application on your smartphone, navigate deep into the privacy dashboard, and switch off the setting that allows the company to save audio recordings for product improvement or human review. Furthermore, you must manually execute a command to delete the existing archived history of your voice commands, permanently severing the historical audio tie to your household. Leaving these default settings active is the digital equivalent of leaving your front door wide open while broadcasting your daily routine to the entire neighborhood. The danger is not abstract or theoretical. The aggregation of this seemingly innocuous smart home data paints a massive target on your digital identity, exposing you and your family to sophisticated phishing attacks, highly targeted identity theft, and invisible algorithmic discrimination based on your private in-home behaviors. Please note that this analysis is provided strictly for educational purposes only and does not constitute formal legal counsel. Understanding the hidden architecture of these end-user agreements is entirely about recognizing the rapidly shifting landscape of consumer rights in the digital age. The burden of vigilance has been entirely shifted away from regulators and onto the individual, demanding proactive, informed engagement with every single digital contract you encounter. For total uncompromising defense, you must move beyond individual device settings and secure the local network itself, implementing a network-wide ad and tracker blocker, such as a Pi-hole or a highly secured DNS service, intercepts the outbound telemetry data before it ever has the chance to leave your home. This technical countermeasure effectively severs the digital connection between your physical device and the data broker's remote servers. By actively blocking the specific internet domains that manufacturers use to upload behavioral profiles, the smart device retains its core, advertised functionality while its hidden surveillance mechanisms are effectively blinded. The TV will still stream high-definition video, and the smart thermostat will still accurately regulate your home's temperature. But the silent, continuous exfiltration of your private life is permanently halted at the router level. Exposing these hidden legal mechanisms is absolutely vital for shifting the balance of power back to the consumer. The current data brokerage ecosystem thrives on the cynical assumption that consumers will never read the EULA and will never possess the technical knowledge to challenge the default parameters. When millions of individuals begin asserting their rights and blocking data extraction, the very economic model of surveillance capitalism begins to fracture. This disruption must also extend aggressively into the legislative arena. While state-level protections provide a temporary, localized shield, true digital autonomy requires the passage of comprehensive federal privacy legislation that defaults to strict data minimization. Public advocacy must focus relentlessly on demanding laws that require explicit, opt-in consent for every single data point collected, rather than trapping consumers in the current, exhausting opt-out maze designed by corporate lobbyists. Until that robust legal framework is established nationwide, your digital defense remains your absolute responsibility. Reject the dangerous premise that a connected modern home must inherently be a compromised, surveilled home. Scrutinize every new device that crosses your threshold, refuse all unnecessary data permissions, and leverage the legal tools currently available to demand the total deletion of your shadow profile. The sanctity of the home is one of the oldest, most fiercely protected legal principles in existence, yet it is being silently dismantled by the very appliances we invite inside. By recognizing EULAs not as mere formalities, but as aggressive legal threats to your personal freedom, you can step out of the shadow of constant data collection and begin to fully reclaim your digital territory. Vigilance is the only effective countermeasure against the creeping normalization of pervasive corporate surveillance. Secure your home network, relentlessly enforce your privacy boundaries, and never surrender your autonomy to a hidden digital contract. Follow for more legal clarity.